Okay, well, I don't see any more creep up in the numbers, so I think we'll make a start here. So good morning, everybody, and thank you very much for joining us for the latest instalment in our Guildhall Chambers webinar series. This morning, I'm going to be presenting with James Fuller on the First-Tier Tribunal property chamber for civil litigators, which I thought might be just a nice, hopefully helpful little run through of some of the quirks and some of the considerations worth bearing in mind with the tribunal. I'm aware from my own point of view, for example, that if someone told me that I was going to be in maybe say the employment tribunal, my first reaction would be to be rather alarmed at that proposition. Not only because I don't do employment law, but also just because it's a different venue and it operates differently. And so it struck me that potentially civil litigators may come across cases that find their way, or maybe should find their way, into the First-Tier Tribunal property chamber and might find that potentially a somewhat daunting prospect if it's not something with which they're familiar. And I thought maybe this would be an opportunity to try to address that a little. There is a disclaimer at the end of the slides, unsurprisingly, but I might as well deal with it now at the outset. This is a talk, it's not legal advice, obviously, so if you've got a specific thing that you're needing legal help with, then take some specific advice on it. And with that said, the way that we're going to proceed is I'm going to talk first of all a bit about what the First Tribunal is, what it deals with, what it doesn't deal with. Then I'm going to hand over to James, who is going to talk us through some of the rules that apply and the way that the tribunal operates and some of the quirks that it has compared to maybe what you'd encounter in the county court or in the high court. And then finally, I'm going to round off with some consideration of some thoughts about tactics and what the nature of the tribunal might mean for litigating in it. So hopefully the slides are changing. And to start with, what is the First-Tier Tribunal? Well, it's a statutory body. And it has statutory ambit, and that's worth understanding. It's not like, for example, the High Court, which has an inherent jurisdiction, and to some extent, unless that's been circumscribed, it can often find for itself a power to do something that appears to need to be done. The First-Tier Tribunal is very much not like that. It is created by legislation, and it is a product of that legislation, and that describes what it can and can't do. It is a part of the streamlined two-tier tribunal system that now exists in England. You have the First-Tier Tribunal with various chambers, the property chamber being one of them, and then you have the potential of an appeal to the upper tribunal lands chamber, or indeed a reference up to that upper level by the First-Tier Tribunal. The upper tribunal lands chamber being what people will often still refer to as the lands tribunal. And it's worth saying that does itself have some first instance jurisdiction. Now, it's also worth saying that in Wales, the system is different. I know that it's been in the news recently regarding the potential for a more coherent tribunal system within Wales to be potentially introduced, but for the time being, Wales still has some of the old tribunals that used to operate in England and don't anymore, like the Leasehold Valuation Tribunal. The First-Tier Tribunal then replaces the old tribunals. It also replaces the Land Registry Adjudicator and references to the adjudicator from the Land Registry. The rules of the tribunal, and you'll hear more about those from James in a moment. For the property chamber, they're in the unimaginatively but helpfully titled Tribunal Procedure First-Tier Tribunal Property Chamber Rules. It's not the CPR. It's a separate set of rules. It has its own provision for basically all the way through the process. But the rules pretty much do what they say on the tin. They're not for someone who is used to civil litigation and is used to digging through the civil procedure rules. They're not a particularly scary or voluminous set of rules to have to deal with. But that's what they are, and that's where they are. And what does the First-Tier Tribunal cover? Well, you can find the allocation of matters to the property chamber in the First-Tier Tribunal and Upper Tribunal Chambers order, Order 5A, but effectively its work is administratively speaking broken down into three tranches, which is residential property work, land registration work, and agricultural and drainage matters. Residential property covers a completely mixed bag of all sorts of things, really. So, for example, and this is, I'm not giving an exclusive list here, but by way of example of what you have matters under the Housing Act 2004 and the Housing and Planning Act 2016, such as appeals in relation to licensing of homes in multiple occupation, and financial penalties. That could be financial penalties relating to HMOs, or it could be financial penalties that have been imposed, for example, because of a failure to comply with some sort of, when I say HMOs, I mean it could be to do with HMO licensing, or it could be to do with failure to, for example, comply with an enforcement notice. Those appeals find their way into the First-Tier Tribunal, as well as appeals from penalties that and decisions of the local authority. You also have directly applications for rent repayment orders, which, as some of you will know, are a weapon in it was being provided in the arsenal to attempt to deal with failings by landlords. So again, that could be in relation to failure to have an HMO licensed that was required to be licensed, or something of that sort. And the application for rent repayment orders, that's in First-Tier Tribunal, and those can be really quite substantial. They might be thought to be fairly simple, routine applications, but actually they can have a lot of complexity to them and can produce really some quite substantial decisions. One thing it's worth saying about the First-Tier Tribunal is it is not afraid, in the right circumstances, of producing really quite an extensive judgment. And then you can also have banning orders being sought in relation to landlords in the residential property division of the property chamber. They have the First-Tier Tribunal has jurisdiction in respect of certain matters relating to park homes, so to mobile homes, to caravan homes. It's a venue for determining that there has been a breach of a term of the lease for the purposes of a Section 146 notice. So for a lot of breaches, it's necessary to have certain triggers, one of certain triggers ticked off before a Section 146 notice under the Law of Property Act can be served. And one of those is that there has been a determination in the tribunal that there's been a breach that's been finally determined, and that is in the Commonhold and Leasehold Reform Act. That's not the only way that a breach can be determined for Section 146 purposes, but that's one of them. Valuation work for leasehold enfranchisement. So if there's an issue over the price at which someone is entitled to freehold, that's a matter for the First-Tier Tribunal. Rent increases for an assured periodic tenancy under Section 13 of the Housing Act 1988. So again, if a statutory mechanism for raising rent is employed and there's a question as to what that rent should be, again, that is something under that provision that gets referred to the First-Tier Tribunal, and questions in relation to right to buy. So you can see that without going into all of those, obviously, each one of those could in itself be the subject matter of a separate talk. And in fact, I'm hoping at some point in the new year potentially to cover rent repayment orders in another webinar, so perhaps look out for that in due course. But there is a wide range of material dealt with by the residential property limb of the property chamber of the FTT under various statutory provisions that refer things to it. Moving on to its land registration work, the power of the First-Tier Tribunal, again, it's a power derived from legislation. It's derived from its being the body to which the land registry, the chief land registrar, makes a reference, and it's its power to determine that reference. That's where the power comes from. That's what the First-Tier Tribunal is doing in that work. That strictly extends then to matters, only to the matters that are actually capable of being subject of an application to the land registry, or something that the land registry needs to refer on. That defines the ambit of what the FTT can deal with on land registration, because it's dealing with things that the land registry has passed to it. So if you're dealing with something that the land registry would simply not be the appropriate body to take an interest in the first place, then it's most unlikely to be something that could fall within the scope of the land registration division of the First-Tier Tribunal. Although, as I'll come on to a little later, the FTT has been held to be able to go a little further in its fact-finding where that's appropriate, rather than strictly just answering a question asked of it by effectively by the land registry. And the FTT also deals with agriculture and drainage work, but for the purposes of this webinar, I'm not going to go into that. So when you're dealing with the First-Tier Tribunal, it's very important to be aware of jurisdiction. The FTT, as I said, it's not the High Court. You really can't just go to it as a default body. You've got to know that it's got jurisdiction for whatever you're taking to it, and indeed how to go to it. And of course, it may be that you don't have direct access to the tribunal. If it's a land registration matter, you take the matter up with the land registry, and if it turns out that there is for example, there's a dispute over whatever you're asking the land registry to do, in due course, the land registry will refer the matter to the tribunal. So jurisdiction is key to dealing with the tribunal. There are some things that the tribunal has exclusive jurisdiction over. So, for example, the valuation work on a reversion for enfranchisement, that is reserved for the tribunal. A rent repayment order, that is work that is tribunal specific. But on the other hand, there are some matters that are just for courts and over which the tribunal doesn't have any jurisdiction. So if the way that you want your boundary dispute to play out is that you actually want to get a possession order against somebody, you're not going to be asking for a possession order in the tribunal. That's something for the court. If you've got other disputes that you want to bundle in to resolving everything together, what I've called their ancillary disputes, but really in the minds of the parties, it may be that they're very far from ancillary. Again, that is something that you will that you will need to potentially go to court over, because if, for example, somebody is saying that somebody else is engaged in harassment, or there's been some property damage, or those sorts of things that may accompany a property-related case, again, that's going to be outside of the scope of what the tribunal will be dealing with. And just to ram the point home, really, anything that isn't actually expressly within the tribunal's scope, anything where you can't identify that this on a statutory basis is something for the tribunal to deal with, or this is something for the land registrar to refer to the tribunal, if it's not in scope with the tribunal, it's going to be out of scope. And then you have concurrent jurisdiction. You have matters that could be in front of a tribunal, or they could be in front of a court. And it's with those that the technical considerations come into play. It's with those that you have to start thinking, well, where should this be if it can be in both places? So some examples of those would be boundary disputes, and I'll come to that by way of example in a moment. Easements, where you're talking about registration issues around easements. The question of the registration of the easement can be referred to the First-Tier Tribunal, but equally, of course, easements get litigated in courts very, very frequently. Alteration and rectification of the register, That is a matter, as you'll probably be aware, that's a matter where the registrar has the power to rectify and the court has the power to rectify. But because the registrar has the power, again, could potentially end up being referred to the FTT to give a direction as to how that power should be exercised. And determinations of breach, I've mentioned in terms of Section 146 of the Law of Property Act that you may well need a determination, final determination that there's been a breach before you can serve a Section 146 notice. That can be one of the triggers for that is that it can be referred to the First-Tier Tribunal and the tribunal can decide. A court can also decide that. So both options, again, available to you. So by way of an example, if we think about a boundary dispute, what can happen if there's a question over a boundary is that a determined boundary application can be made where basically one party sends in a plan and asks for that plan to be effectively defined as determinative of the boundary. Now, in the case of Lowe and William Davis Limited a few years back in the upper tribunal, this was considered, and it's fair to say that there are some complexities here because perhaps obviously the tribunal can determine a question that's referred to it by the Chief Land Registrar, which in this case will be, well, what to do with this determined boundary application. Effectively, is it satisfied that the plan is accurate? And that obviously is a question that the tribunal can answer. And it's right, of course, that whilst the tribunal might have a matter before it, which is really just, as it were, a technical dispute about whether the plan's accuracy is adequate, it may well be that what really underlines the question of is this an accurate plan is a full-blown dispute as to where, as a matter of reality, the boundary is. Now, the tribunal in that context obviously may well have to determine the factual question of where the boundary is, because determining where the boundary is will therefore potentially determine whether the plan is accurate or not. But what is the situation if in fact the plan itself is inadequate, so the tribunal is going to have to direct that the application be rejected regardless? Can the tribunal still go on to actually make substantive findings about the reality of the boundary? And this was a case that was argued out in the context of some potentially conflicting upper tribunal case law in the case of Lowe, and the judge in that case concluded that, well, yes, the tribunal still had that power. The tribunal had, as a matter of case management, the ability to answer the questions asked of it in whole or in part, because it has the power to direct that part of an application be allowed. It could determine that in two ways. It could simply say, well, look, there's a problem with this plan, so that's it. Or it could say, well, first of all, we're going to find where the boundary really is. And having made those findings, we're still going to reject the application because the plan has a technical problem. Now, there seems to be an open question, a floating question, as to whether if the tribunal does that, as to if it makes a determination as to where the boundary is, but not one that ultimately results in a determined boundary being established, as to whether that creates an issue with estoppel, and as to whether people can actually go back later and have the same argument again. So it is indicated in that case that it may well be that when that sort of thing comes up, the tribunal may not wish to go all that way. It's often going to be the case that this is one of those matters that the tribunal will say should be resolved in court. Generally speaking, if matter is part playing out in the tribunal and then it legitimately, non-abusively comes to also be before the courts in a fuller version, the tribunals will often leave them, stand aside to let the court determine it. And that might be the better approach here if there are question marks about what the effect of a tribunal determination will be as to the true boundary. But theoretically, it appears to be the case, or at least on this case law, that the tribunal could make a load of findings about where it finds the boundary to be, and then determine that the application should be rejected because the plan isn't accurate, but leave those findings potentially, as it were, out there. It's worth remarking that, in fact, what you also might find is that boundary disputes are making their way in front of the tribunal not through a determined boundary application, but through somebody requesting the land registry to update the title plan to show a more accurate general boundary. And again, that's something that can find its way before the tribunal, which is effectively asking the tribunal to make findings as to the true boundary. So if you've got a situation where you've got concurrent jurisdiction, what do you do with that? Well, there are a few things to think about. One is, do you need an answer to a question, or are you looking for something else? If you are looking to remove someone from land, for example, if you want the power of the court to make a possession order or an injunction or something like that, if you need additional relief, and as I said, if you've got other elements of the claim that you want to bundle in, those are all pointers towards going to court. If you, for example, on the other side of the coin, if you're actually trying to get something sorted out with the land registry and it turns into a dispute and the dispute is going to be referred to the tribunal, you might well take the view that if the tribunal's got jurisdiction to deal with it and the land registry is in the process of referring it, there's no earthly reason to complicate matters by running off separately to court. And it may be that you think that the tribunal procedure might be a little more streamlined for dealing with the matter anyway, and you might just much prefer to leave it where it is. Are you in a hurry to get before a tribunal? When I say a tribunal, I mean a tribunal in the broad sense, because if you need urgent relief, if the issue about the boundary is something that needs to be resolved imminently, you can get an urgent application before a judge in a court. You can get some sort of urgent interim relief. You may not want to be waiting for the land registry to refer the matter to the First-Tier Tribunal, and that might make the decision for you in favour of the court. Indeed, the land registry will often have quite a lot of back and forth trying to hammer out if there's a dispute, what people want to do people want to mediate, etc. So before you get to the stage where actually the land registry is making a reference, that in itself may take quite a bit of time. So again, if you're in a hurry, if you're in a big hurry, the tribunal may not be the venue for you. And with that, I'm going to hand over to James, who is going to talk you through some of the tribunal rules. Now, James, I don't know if you want me to keep clicking through at the appropriate point for you.
If you could, I'd appreciate it.
Just give me a shout if I don't.
Good morning. So, as I said, I'll be looking at the rules. So, the tribunal procedure, First-Tier Tribunal Property Chamber rules are a single set of rules that cover all of the divisions of the property chamber, which, as Oliver set out earlier, comprise of the agricultural land and drainage division, the land registration division, and the residential property division. As a background to the tribunal rules, and before considering them in a little detail, I would first like to fix your mind on 4 aspects of the nature of the tribunal and its rules, which are useful to bear in mind. First, the rules contain many similar features to the civil procedure rules, and this is because the rules and the CPR are both fundamentally designed for adversarial litigation. So if you've dealt with the CPR before, as I'm sure you have, then the rules should be something you'll be relatively comfortable looking at. Second, the rules use language that is adversarial in nature, referring to parties rather than participants, and formal pleadings are described in the traditional way as sort of statements of case. Third, given the adversarial nature of the rules, coupled with the way that they are applied in practice, determination of disputes in the tribunal is sort of seldom quicker nor cheaper than going to court. It's another thing to bear in mind. And fourth, as the tribunal is structured in a traditional adversarial manner rather than inquisitorial, the function of the judge in the tribunal is essentially to determine which case advanced by the respective parties, which are referred to as the applicant and respondent in tribunal proceedings, is more likely to be correct. Tribunal judges therefore only have a limited scope under the rules to make their own inquiries and arrive at a conclusion that is different from the case being advanced. However, I would emphasise that in practice, the rules are merely the framework of the tribunal, and if a tribunal judge is prepared to apply them flexibly, as some indeed are, the adversarial nature of the rules can be mitigated. And then one final point before looking at the rules in a little detail, I would add that perhaps due to the adversarial nature of the tribunal, there's a tendency for parties in proceedings to wish to litigate or raise points which the tribunal doesn't have jurisdiction to deal with. And this is something Oliver touched on earlier. It's therefore worth bearing in mind and reminding clients to focus on what issues the tribunal can actually make a decision on. Focusing a client's mind on the actual decision the tribunal can make from the outset, or what it can do, is a helpful exercise in controlling costs and the volume of disclosure, which can often be great if the matter's emotionally charged. Controlling these is something I'm sure the judge would be thankful for. Turning now to the actual rules of the tribunal. These are set out in 6 parts. And you should hopefully see them on your screen in a moment. And if we just go to the next slide, here they are. Thank you. I'll just give you a moment to cast your eyes over them. You can see here that, 6 parts, all dealing with different parts of the tribunal, and part 5 is split into 3 chapters, which are specific to the different divisions. It's obviously beyond the scope of this webinar to cover all of the rules, but I would like to draw your attention to some of the main rules today. So moving now to part 1 of the rules, I'd first like to cover Rule 3. And this provides that the overriding objective of the rules is to enable the tribunal to deal with cases fairly and justly, much like the overriding objective in the CPR. And this sets out that dealing with a case fairly and justly includes first dealing with the case in ways which are proportionate to the importance of the case, the complexity of the issues, and the anticipated costs and resources of the parties and of the tribunal. Second, avoiding unnecessary formality and seeking flexibility. Third, ensuring that parties are able to participate fully. Fourth, using any special expertise of the tribunal effectively. And finally, avoiding delay so far as it's compatible with the consideration of the issues. Rule 3 also provides the tribunal must try to give effect to the overriding objective when it exercises any power under the rules or interprets any rule or practice direction. And says the parties must also help the tribunal to further the objective. In making an interim application in the tribunal, it can be useful, as it is under the CPR, to frame such application in line with the overriding objective. Moving now to Rule 4, this deals with alternative dispute resolution. It's the final one I'll cover in part 1. And this actively requires the tribunal to make parties aware of alternative dispute resolution, and if it's considered suitable, then to facilitate the use of it. And in many cases, the tribunal offers a free mediation service, usually up to a limit of 1 day, although it can be shorter. Moving now to part 2, this covers the majority of the rules that I'll be focusing on today, and dealing first with Rule 6. This is the case management powers of the tribunal, and these are broad and far-reaching in a similar way to those of the court under Part 3 of the CPR. Under 6.1, the tribunal is given a general power to regulate its own procedure, and 6.2 may give a direction in relation to the conduct or disposal of proceedings at any time, and may suspend or set aside earlier directions. Rule 3, 6.3, you'll see on the screen, this is the a non-exhaustive list of the tribunal's general powers. It is quite long, but I believe it's worth running through, as please do bear with me. So the list includes powers to extend or shorten time for compliance, consolidate 2 sets of proceedings or treat a case as a league case, permit or require a party to amend a document or provide documents or submissions, direct inquiries to be made of a person, requiring party, if they intend to attend a hearing, be represented or call witnesses, hold a hearing and consider any matter, including a case management issue, decide the form of a hearing, adjourn or postpone, require a party to produce a bundle, provide an estimate length of the hearing, stay proceedings, transfer proceedings to another jurisdiction, or suspend the effect of a decision pending determination of an application for permission to appeal. So a lot of these you'll recognise as similar powers from the CPR. Moving now to Rule 8. This is sort of sanctions failure to comply with directions, and it sets out that in cases of a party's non-compliance with a rule or practice direction or a tribunal's direction, the tribunal may take such action as it considers just. And this power includes, but isn't limited to, waiving the requirement, requiring the failure to be remedied, striking out a party's case, or barring or restricting a party's participation in proceedings. Rule 9 deals with striking out. And under Rule 9, the tribunal make unless orders. And under 9.2, the tribunal must and is therefore obliged to strike out the whole or part of a case if it does not have jurisdiction in relation to the whole or part of proceedings, and it has not transferred or has not transferred the whole or part of the proceedings to another court or tribunal. These are therefore mandatory strikeouts. Alternatively, the tribunal may strike out the whole or part of a case if the applicant has failed to comply with the direction which stated that failure could lead to a strikeout, or the applicant has failed to cooperate with the tribunal. Third, the proceedings of the case are the same between the parties arising out of facts which have already been determined. Fourth, the proceedings are considered frivolous, vexatious, or an abuse of process. And finally, the tribunal considers that there is no reasonable prospect of the applicant's case succeeding. Except where automatic strikeout operates, the tribunal will give the parties a chance to make representations before making a strikeout order. So that's worth bearing in mind. I'll now look at Rule 10 very briefly. This just allows the tribunal to add, substitute, or remove parties. And 12 is security of costs. And this only applies in land registration cases where a respondent may apply for security for the respondent's costs of the proceedings in the tribunal. And the reason that is the land registration is separated out is because of the costs rules under Rule 13, which we'll come on to now. So this says the tribunal may make an order in respect of costs only, A, for wasted costs, or B, if a party has acted unreasonably in bringing, defending, or conducting proceedings in either an agricultural land or drainage case, residential property case, or a leasehold case, or it may make an order in respect of costs in a land registration case. It's therefore worth noting specifically that the tribunal provides that it may only make orders for costs of another in a land registration case, whereas in all other cases, the power of the tribunal to award costs is restricted to where a party has acted unreasonably or where wasted costs have been incurred. I'd also highlight that Rule 13.5, which provides that an application for costs must be made within 28 days the tribunal sends the order recording the decision which disposes of the proceedings at the latest. So moving now to the sort of fact-finding investigatory powers of the tribunal. Rule 19 deals with expert evidence and gives the tribunal the power to direct that a single joint expert is instructed. And this Rule 19 affords the tribunal a large degree of control over expert evidence. And this includes imposing duties on experts, providing that no expert may be adduced without the tribunal's permission, which must also provide a written report unless directed otherwise, provide a copy of the report to all the parties, and the tribunal may also direct that expert in particular to focus on limited certain issues or give evidence at the tribunal. Looking at Rule 21 now, this concerns site inspections and provides a very sort of practical power to the tribunal as it allows it to inspect the land, property or premises which are subject of an application, or any other land, property or premises, the inspection of which may assist the tribunal in determining the application. And then finally, the general locality of the land, property or premises. All of these powers, of course, are subject to provisions related to consent and notice and so forth. Two final rules of Part 2. This is Rule 23, which deals with lead cases, and where two cases are before the tribunal and have yet to be disposed of, and they give rise to common issues, the tribunal can direct that one or more of the cases lead in front of the other case whilst that is stayed. Thank you. And Rule 25, which is similar to Rule 6.3, which covered earlier, allowing the transfer of proceedings to another jurisdiction. Rule 25 provides the power of the tribunal to transfer proceedings to the upper tribunal, which Oliver was discussing earlier. Moving now to Part 3. I'm only going to briefly mention it, really, because we don't have the time to deal with it today. But this concerns the rules regarding starting proceedings, time limits, referred and transfer cases, notices and response. Part 4, again, this is something beyond the webinar today, but as you can see, it covers the rules relating to the hearings, so decision with or without a hearing, notices, public and private hearings, consent orders, decisions, and so forth. I would point out on Rule 36, just something to bear in mind. Sometimes a judge does give a decision straight away, but in many cases, the decision will be delayed with the reasons given later in writing and sent to the parties involved. And that's a power they have under Rule 63.2. Part 5, this is the special procedures. As you can see, there's a different chapter per division, and as Oliver mentioned earlier as well, this is going to be beyond the remit of this, but just any specific rules related to things, for example, Agricultural Holdings Acts or something like that, will be dealt with under one of these chapters. And now finally, moving to Part 6, this concerns rules regarding correcting, setting aside, reviewing and appealing decisions. Rule 50 is a useful power, the slip rule, which allows the tribunal to correct clerical mistakes, accidents, slips and omissions. 51 concerns setting aside a decision and provides that the tribunal may set aside a decision or part of one if it A, considers that it's in the interest of justice to do so, and B, one of the following 4 conditions are met. And that's that a document relating to the proceedings was not sent or received at the appropriate time, or a document relating to the proceedings was not sent or received by the tribunal at an appropriate time, or a party or the representative was not present, or finally some other procedural irregularity in the proceedings has occurred. Rules 52 and 53 deal with applications for permission to appeal. 52 provides that permission to appeal must be made in writing to the tribunal, and in that regard, a letter would simply suffice. And also that an application for appeal must be made within 28 days of the latest date that the tribunal either sends the written decision, an amended reasons or decision following review, or notification that an application to set aside has been unsuccessful. Rule 53 covers the tribunal's consideration of the application to appeal. When the tribunal receives such an application, they must first consider the overriding objective in deciding whether or not to review the decision. Should the tribunal decide not to review a decision or decides to take no action following a review, then the tribunal must consider then whether to grant permission to appeal. And it's if and only if the tribunal refused permission to appeal, then the party making the request may make a further application for permission to the upper tribunal. And that's something perhaps, for another day. Finally, Rule 55. And this provides the tribunal may only review a decision by the tribunal on an application for permission to appeal, and if satisfied that a ground of appeal is likely to be successful. And where the tribunal reviews a decision, it may either correct accidental errors, amend reasons given for a decision, or set the decision aside. And if it decides to set a decision aside, it must either re-decide the matter or refer it to the upper tribunal. That concludes my very whistle-stop tour of the Tribunal Rules, and thank you for bearing with me. I'll now pass you back to Oliver, who will be discussing some tactical considerations in respect to the tribunal further, I believe. Thank you.
Thanks, James. So one thing to be alive to when you're dealing with a first-tier tribunal is the fact that it is a specialist tribunal. I mean, that's sort of obvious in a sense, but it is worth thinking about the considerations of that. That means that the tribunal judge is likely to be very familiar with the workload of the tribunal and the process of the tribunal, and that probably brings with it advantages in terms of the fact that often when something is a bit complicated, it's easier if you're dealing with a judge who is familiar with what's going on in essence. But of course, that's offset by the fact that cases can be quite technical. These can be there can be quite technical points about, well, all sorts of things, whether a rent repayment order is available, or technicalities of the of whether a boundary plan is accurate, or whatever it might be. The work the tribunal is doing is often far from straightforward. So in that sense, it's just as well that the judges are specialist judges. One thing that obviously looks very different from the point of view of a civil practitioner used to the courts is that you are likely to be confronted with a panel. So in that sense, it looks like the employment tribunal, in that you will have a tribunal judge, and then you will have two wing members. You don't always have a panel of three. The tribunal judge will sometimes sit alone, but look out for expecting and pre-warn your client potentially to not be surprised by the fact that if you are dealing with a substantive hearing in front of the tribunal, you're probably going to be dealing with a panel of three people. And in that sense, obviously, it's just something to be aware of. It's worth being aware that you may well have someone who is, for example, a surveyor sitting there taking things in from that point of view on the panel, and it's worth just being aware of the fact that in terms of the practicalities, you will be having to potentially present the thing to three people. Also, expect to go away wondering what the result is. Very much the usual thing is that the tribunal gives a written judgment at a later date, in part, I suppose, as a result of the fact that obviously if you've got a panel of three people, they're going to need to confer. So again, it's worth teeing the client up to be aware of the fact that just because the matter might be being dealt with in, say, half a day, and might be the sort of matter where if it was in the county court, you might very well expect to see an ex tempore judgment given straight away by the judge. If it's in the tribunal, the client can expect to go away not yet knowing the result and to find out later. Now, James has taken you through some of the rules in detail that apply. It's worth just taking a slightly holistic view of some of the differences that you'll encounter. Statements of case, for example, are different. They look different. They're different in form. For example, you'll see that there's a list appears at the end, a table listing documents, which is not something that you would see in a statement of case ordinarily in most civil proceedings in the courts of the sort that we deal with in our area, at least. However, the tribunal tries to be helpful, and one thing that you may well see, for example, is an example that the tribunal sends out to help you understand the sort of thing that it expects of you. It is actually trying to be a user-friendly jurisdiction. It is a jurisdiction that all courts and tribunals have to expect to have litigants in person having to deal with their own cases these days. That certainly applies of the property chamber, in the sense that you will have issues about, for example, rented properties being brought very routinely by litigants in person. You will have matters that have been referred to the land registry and have found their way with parties who have sort of found their way on a reference in litigation who maybe wouldn't actually have launched into litigation in a court without getting lawyers, but might in the tribunal after a reference. So it is a tribunal that is well used to having to make itself accessible and workable for litigants in person. It is not trying to make life difficult. So yes, look at the rules and the orders, but usually speaking, the answer will be available, and the tribunal is not looking, I think it's probably fair to say, it's not looking to be difficult, and it's probably not looking to be the sort of tribunal where errors in terms of procedure are punished ruthlessly, although it's right, of course, that there's always risk associated with making those procedural errors. Costs, another big difference. James has obviously dealt with it, but another big difference if you are a civil litigator and you are used to the basic concept that costs usually follow the event. There's one simple headline point, I think. Check it. Check whether, in fact, what you are dealing with in the tribunal is ordinarily a costs-free territory, or is part of the work of the tribunal, basically land registration, where you can expect a cost order ordinarily to follow. That is simply something that you don't want to forget as a civil litigator, because if you tell your client that there won't be costs and it turns out that there will be costs without anyone having done anything unreasonable, or if you launch into extensive litigation in the tribunal that you expect to win and forget that it's likely to be a costs-free outcome, that could be unfortunate. So just make sure that you are aware of what the cost position is. The tribunal also has the ability to demonstrate the sort of joined-up thinking that can actually be useful to a professional and can really oil the wheels of making things work efficiently as a result of the fact that it is, I suppose, a specialist jurisdiction. So one example would be the process for enfranchisement, where you have a missing and untraceable landlord, because in that context, there is a process for that. There's a statutory power to deal with that, and there's a process to be followed there. And the basic process involves going to the county court to get an order saying that the leaseholder is to have the freehold, then a valuation exercise in the first-tier tribunal, and then the county court finalising the conveyance once the first-tier tribunal has said how much is to be paid. Those are distinct jurisdictions which are exclusive to the separate tribunals. The county court's role there is for the county court and not for the tribunal, and the tribunal's role is exclusively for the tribunal, that valuation exercise. You can't do that whole process simply in court or simply in the tribunal. And that, frankly, can be rather difficult. It's difficult because actually getting your head around what the right process and order of steps is not easy. And it's difficult just because it can involve bouncing around, getting orders in different places and taking them to other places to get further determinations. It can be, given that you're often dealing with something which is basically fairly uncontentious and where the value might be quite low, it can be a bit of an awkward process. One process you might find, however, is that if you have one of those cases, when you bring the matter into the county court, you may find that it's transferred to a hearing centre that deals with tribunal business. And you may find that the tribunal judge then does something quite clever with wearing different hats, whereby the tribunal judge will first sit as a judge in the county court, exercising the jurisdiction of a district judge, which the tribunal judge will have the ability to do, and will determine the first bit and decide that there, well, from your client's point of view, if you're the applicant, hopefully decide that there should be an order that your client has for freehold. And then we'll transfer the matter to the first-tier tribunal, put on the hat of the first-tier tribunal judge, make directions for the valuation, and then the valuation can subsequently be carried out in the first-tier tribunal, whereupon the judge can then put on the hat of the county court district judge again and carry out the process of finalising the conveyance. So although you have the two separate jurisdictions, the whole process can actually be dealt with in the same building with the same back office and potentially by the same judge. It is rather clever, and it has the potential to be really quite time-saving and cost-saving. Finally, some do's and don'ts, just that I would suggest for overall if you're coming across the tribunal. Firstly, do check the procedure and the rules and the orders. They are not, frankly, something to be unduly worried about if you are used to wrestling with the civil procedure rules, but they are different, so check them. Check the costs position, because that might well be different and you don't want to be caught out by that. And think carefully about whether there is a reason why the matter should be proceeding in the court or should be proceeding in the tribunal, either because actually there is some provision that requires it to be in one or the other, or if it can be in both, whether there's some tactical reason why it's better off in court, or whether you're happy to have it run in the tribunal. Don't expect to win easily on, as it were, pure sort of procedural points. Obviously, that's not something you should necessarily expect to do at all, but particularly in a jurisdiction like the tribunal, if you've got litigants in person on the other side who are maybe putting in statements of case that maybe occupy that slightly blurred territory between a pleading and a witness statement and that sort of thing, trying to take those points might prove to be an exercise in frustration. So it's perhaps best to sort of to moderate the extent to which you would take points like that. That's as opposed to what I've called technical but substantive points. Tribunal cases absolutely can be technical. You absolutely might win on a technicality of the substantive law. That's a very different thing. But on pure procedural errors by a party, perhaps it's best to be realistic about that. And final, don't be afraid of proceedings in the property chamber. It's a different jurisdiction, but it's a very useful jurisdiction. And if you are used to the county court, just have a look at the rules, have a look at what the tribunal is sending out, and you should be perfectly capable of running your case in the tribunal with every bit as much success as you might in the courts. And of course, and I would get the plug in if you have an issue with that, with a case of that sort that you would like some help with, then I'm sure that there are people in our team in Guildhall who would be more than happy to have a look at that for you. And finally, there I'll put it up on screen, the disclaimer that I mentioned. This is a talk; it's not legal advice. I hope that's been a useful whistle-stop tour of the tribunal and what you encounter within it. I don't know if we have any questions or comments that anyone's raised in the chat. If anyone has any, then feel free to do that. I can't see anything at the moment, but we'll wait and see for a few moments and see if anything like that comes through. I don't want to preempt anything, but so far I'm not seeing anyone jumping in with any brain teasers just to see if they can find out what we don't know. So on that basis, I think it only remains for me to as I say it's now hitting 10 o'clock bang on. So to say thank you very much for your time this morning and for attending virtually to listen to what James and I had to say. I hope you found it useful, and do look out for some more webinars coming up from Guildhall Chambers in the future. Thank you very much.
Thank you.